been charged with a criminal offense and you retain a lawyer and you go to that lawyer and say, look, I'm completely innocent. In fact, I'm the victim. For example, my wife charged me. She had the police attend. She made a 911 call. The police showed up and they wound up charging me, and she is the one who assaulted me. So clients will often ask me, should I lay a counter charge in this situation? Will that be helpful in not trying to negotiate these to be withdrawn? I want to put the blame on her. This is a very loaded question. Each situation has to be applied, each factual situation, and you have to speak to a very good lawyer who knows what they're doing, whether to do this, okay? The problem with laying a privately laid criminal information, that's where you go before a justice of the peace and give your version of events in writing, is now you're revealing all of your facts to the Crown so that they have a chance to cross-examine you at trial. I don't want to give I can give some generalizations. In a domestic assault, it rarely, if ever, and I frankly never do it and wouldn't advise it to lay a countercharge, because the way it politically is in the province, if you're a man charged with domestic assault, it's not going to help you to lay a countercharge. End of story. There are some narrow situations, and I would have to look at it carefully, each situation. For example, if you got in a bar fight where you were attacked and you have your own witnesses, in that situation, it might be effective to lay a countercharge, but every situation has to be looked at very carefully. By and large, countercharges are not effective. Can they be effective in a narrow factual situation? The answer is yes, if you go to a good lawyer who can analyze it and figure out, does this maximize my chances of winning the case? I can tell you this, in a domestic assault, if you try and lay a countercharge and give you the Crown your version, that minimizes your chances of winning a case because it's not going to be effective.